As you know from your readings, the Constitution of Canada divides rule-making authority between the federal and provincial governments, and there's a charter that prevents the governments from writing certain types of rules. But the charter wasn't always there, and the charter may not always be there. Let's take a hypothetical case of the parliamentary Christmas party. And well into the evening, the parliamentarians decide, hey, let's pass a rule that says all blue-eyed babies need green tattoos. Yeah, and it's late in the evening at this point, and Parliament says, yeah, let's get everybody together. Hey, come here, let's do that. And in their celebratory nature that evening, they pass a law that all blue-eyed babies will have green tattoos. Perhaps that's why we have a Senate for sober second thought. But assume the law is passed by Parliament and there's not a requirement of Senate approval. Now we have this law made by the Parliament. The question is that a rule of law? Some would say, gee, law has to have some sort of rightness to it, some sense that it's morally correct, some sense of fairness and justice. Others say, no, all you need, this would be the positivist rule makers, with reference to those who say there's a sense of fairness, of justice, of correctness to the rule. We've read elsewhere in the course of Lon Fuller's 8 requirements for a legal system, and most of us have agreed that if any of those were missing, it would seem odd. But the positivist rule makers would say the content of the rule is not what is relevant. The question is, was it created by the correct parties following the correct procedures? So, was the rule created by a government creating a statute following the correct procedures for creating a statute? And if so, it's a rule of law, regardless of the content. Or was it created by the courts writing a decision? If so, it's a rule of law, regardless of the content. So the question is relating to whether or not the rule was made through the correct lawmaking process. If it was, it's a rule of law without regard to content. That solves a problem of determining what rule is a rule of law and what rule is not a rule of law. Because if you don't go based on the process of creation, then there's possibilities for differences of opinion. For example, one person could say that the green tattoos has no moral problem. Someone else may say green tattoos do present a moral problem and therefore there shouldn't be a law about them or requiring them. The difficulty is that moral requirements differ from person to person, much more so than does answering the simple question, was the rule created through the correct process of creation? There can be general agreement on whether a rule was created through the correct process of creation, where there may be general disagreement on whether or not a rule has the required moral content.